Hello, I'm Orange County Executive Steve Newhouse. Orange County government is committed to having a workforce that adheres to the highest ethical standards. This training video will explain to you what behavior is expected in respect to the Orange County ethics law. I want to thank all my coworkers who helped make this video possible and thank the entire county workforce for all the hard work that they do to make Orange County a great place to live and work.
Welcome to our training on the county's Code of Ethics. As you may be aware, the county adopted an updated Code of Ethics, which is found in County Local Law Number 1 of 2017. And you can find a copy of it on the website, and there's also a copy in the materials that you will receive today. Now, that Code of Ethics substantially revised the expectations for your conduct while employed by the county or if you are affiliated with the county. The Code of Ethics covers employees of the county as well as other officers of the county, whether they are paid or unpaid. So it includes all members of any office, board, body, advisory board, council, commission, agency, a department, division, a bureau, or a committee of the county. So it has very broad coverage, and our training today is specific to those employees or officers who are required to file an annual disclosure statement. Today I will be summarizing some of the rules that apply to your conduct while you're employed by the county, or while, if you're not an employee, but while you're associated with the county, as well as the rules that will cover you even after your relationship with the county ends. Now, all the examples that I'm going to give today are fictional. They are hypothetical situations. They do not involve any current or former employee or officer of the county. They do not involve any actual situation here. They are purely examples given for your understanding of the law. What we are doing today is providing you with general guidance, not specific advice. This general guidance is to help you identify when you may have an issue or a concern for which you need to get more specific advice. To the extent that you have specific questions about matters that involve your relationship with the county, you need to address that with your supervisor and with the county's Board of Ethics. And if for any reason you are not comfortable speaking with your supervisor, you can absolutely go directly to the county's Board of Ethics to get guidance. The Board of Ethics has the ability to issue to you a written advisory opinion to give you guidance as to how to act. They can only give you that written advisory opinion regarding future conduct, future events. They will not give you a written advisory opinion about something that has already happened. So if you anticipate that there is a situation coming up that may involve an ethical issue, you should immediately write to the Board of Ethics so that you can receive guidance as to how to proceed. The county's Code of Ethics has to be read in conjunction with the state general municipal law. The state law and the county's requirements, whichever one is more stringent, is what applies to your employment. So there are areas of the county's Code of Ethics that have additional requirements beyond what is contained in the state law. So it's very important that you be sure that you're in compliance with both, and whenever there is a stricter requirement, that you're following the stricter requirement. The first topic that we're going to cover has to do with expectations for your conduct as a county officer or employee. Now, you cannot use your official position or office, and you cannot take or fail to take any action in a matter where you know or you have reason to know that it may provide a personal financial benefit. So by personal financial benefit, money, service, a license, a permit, gratuity or travel, entertainment, anything of any kind of value. You can't use your official position or office, and you can't take action or fail to take action in a matter where you know or have reason to know that it may provide you with a personal financial benefit or secure an unwarranted privilege or exemption for yourself, for any person, any employer, business, or prospective employer of any person. And by prospective employer, we're talking about someone from whom you or a relative or immediate family member has sought employment from within the past 12 months. Now, by a relative or immediate family member, we're not talking about just any relative. You have lots and lots of relatives. The term relative or immediate family member, as it's used in the county's Code of Ethics, includes your spouse, your unmarried child or stepchild who is under the age of 18 and who lives with you, or somebody who is declared as a dependent on your tax return. Now, as a county officer or employee, you also have an obligation under the Code of Ethics to avoid creating conflicts. You cannot knowingly acquire, solicit, negotiate for, or accept any interest, employment, or anything of value which would put you in violation of the county's Code of Ethics. So that includes, but isn't limited to, soliciting employment for yourself, your spouse, or a child, including a stepchild who's a member of your household, with any county contractor, if you have discretion to award a contract to that contractor or to appropriate money for that specific contract. The county ethics law also requires you to recuse yourself in certain situations. Now, by recusal, it means that you're going to exclude yourself from any discussions and any further participation in the matter. Now, you have to recuse yourself from acting on a matter that is before the county when knowingly acting on the matter or knowingly failing to act on the matter may cause a direct or specific benefit to you, to your outside employer, business, or prospective employer, to your relative or immediate family member, and by relative or immediate family member, that definition that I just gave you still applies. That would include your spouse, your unmarried child or stepchild who's under the age of 18 and who lives with you, or somebody who is declared as a dependent on your tax return. You also have to refrain from acting on a matter where it may cause a direct and specific benefit to the outside employer, business, or prospective employer of your relative or immediate family member, or to your customer or client, which would include anybody to whom you directly supplied goods or services within the last 24 months. As an example, your office processes applications to use the county park. There's a pavilion, and your office is responsible for processing those applications. And there's a fee for using that park. You have a second job. You have an outside job in addition to your employment with the county. And your other employer puts in an application to use that county park and to use that pavilion. So you would, in that situation, you would need to recuse yourself. You can't process that application, and you certainly can't waive the fee for your other employer to be using that pavilion. So you recuse yourself, somebody else has to handle that situation. You don't discuss it, you don't have anything further to do with that situation. To recuse yourself, you would promptly inform your supervisor in writing, and you would file with the Board of Ethics a signed statement disclosing the nature and extent of the conflict which forms the basis for your recusal, and you would immediately refrain from any further participation in that matter. In your capacity as a county employee or officer, there are certain contracts that may come before you that involve either an outside entity that you have a relationship with, or that somebody in your family has a relationship with, where you may have an interest in that contract. If you have an interest in that contract and you have any control over the process of recommending or approving that contract or appropriating funds for that contract, then you have to get guidance. You have to get guidance to determine whether you have what's called a prohibited interest in the contract, or whether it's a contract where you can disclose your interest, it's not a prohibited interest, and that contract can go ahead without you being a part of that process. So by contract, I'm talking about any kind of claim, account, demand against, or agreement. It could even be an oral agreement involving the county. It could be a contract to supply services. It could be a voucher for goods. If you have currently, or if you will in the future, have an interest in that contract, and by interest I'm talking about a direct or an indirect pecuniary or material benefit would accrue to you either now or in the future, or to your spouse, to your unemancipated child, so that would be a child or a stepchild of yours who is living with you, who is under the age of 18, or if it involves a dependent who's declared on your tax return, or somebody who is living in your household currently or who has regularly lived in your household within the past 12 months, you can't be involved in that contract other than there's an exclusion if it's a contract of employment with the county. Nothing prohibits your relatives from being employed by the county. There is also an exclusion for any benefit arising from the provision or receipt of any services generally available to county residents or to taxpayers, or from any political subdivision of the county, or that's available to a class of county residents or taxpayers. Also excluded from the definition of interest are any benefits or entitlements that are procured for the benefit of county employees or officers. So, for example, things such as union membership, health insurance, vision and dental benefits, deferred compensation, and disability benefits. You could also have a direct or an indirect pecuniary interest based upon your interest in a firm, a partnership, a company, an association, or a corporation where you're a member, where you're an employee, an officer, or a director, or in any corporation where the stock is owned by you and controlled directly or indirectly by you, 5% or more of the outstanding stock. That excludes publicly traded corporations. So that's when you would have an interest in a contract. In terms of control, you have control over a contract if you have the power or the duty to negotiate, to prepare, to authorize, or to approve the contract, or to approve payments under the contract, or to audit bills or claims under the contract, or you even have control if you have the power or duty to appoint an officer or an employee who has one of those powers to negotiate, prepare, authorize, or approve the contract or payments under the contract, or to audit bills or claims under the contract. If you have a contract where you have an interest in the contract, but you don't have control over the contract, then you would have what's called a non-prohibited interest in the contract. You would disclose your interest as soon as you have knowledge of the actual or prospective interest. You would publicly disclose it. In writing, you would lay out what the nature and the extent of your interest is, and you'll send that writing, and it can be an email, to your immediate supervisor and to the clerk of the county legislature. That disclosure becomes part of the official written records of the county legislature, and the clerk of the legislature will then file that disclosure with the county executive and with the county board of ethics. In addition, you will disclose that on your annual financial disclosure statement because you're all required filers. You will also recuse yourself from anything more having to do with that matter. Now, if you have an interest in the contract and you have control over it also, then you have to look at whether a statutory exception applies. The New York State General Municipal Law contains a number of exceptions where your involvement in a contract will be permitted, even though you have interest and control over it. I'm going to cover just some of the more common ones, but there are additional exceptions. Now, the first and probably the most common is where your interest, your otherwise prohibited interest, is solely because you were employed by a private business and your compensation in that private employment is not directly affected as a result of the contract. And your employment duties in that private business don't directly involve the procurement, the preparation, or the performance of the contract. So, for example, you have your job at the county, and then you also have your side job. And your side job involves answering the phones at this private business. You get paid just an hourly wage. You just work a few additional hours a week for this private business. You're not responsible for procuring contracts for them, for preparing them, or performing. You're just answering the phone. So your compensation from that private business is not going to be affected if they obtain a contract with the county. So that would fall within the statutory exception where your interest in that contract is not prohibited. Another example is you're new to the county. There was a contract that was entered into that you have an interest in that was entered into before you came to work for the county. Well, a contract that is entered into before you become an employee or an officer in the county is subject to an exception, and that contract can continue in place. However, when that contract expires, unless one of these other exceptions apply, the renewal of the contract would be an issue because a new contract can't be issued unless it comes within one of these exceptions. Another common one is if your interest is in a contract with a not-for-profit organization. We know many county employees have involvement in not-for-profit organizations, and this is a statutory exception that would apply to a contract that comes before you involving a not-for-profit organization where you may have an interest in that contract. It also includes a contract with a municipal union. If an exception applies, it's okay for that contract to go ahead, but you still need to disclose that interest using the procedure that I laid out before. You need to send it in writing to your supervisor, to the clerk of the legislature, disclosing the nature and extent of your interest, and they will then submit it to the legislature, and then it will be filed with the Board of Ethics and with the county executive. Now, if you have an interest in a contract and you have control over the contract and it doesn't fall under any of those statutory exceptions, then you have what's called a prohibited interest in the contract. The contract itself would be void. It can't be ratified by somebody else. It can't be enforced. And you can't cure that prohibited interest by sending out the contract for public bidding or by recusing yourself. This is something that cannot be waived. And a violation of that provision could even be result in disciplinary action or even a misdemeanor. So if you're in that situation, you need to get guidance. You need to obviously speak with your supervisor, but you also need to be communicating with the Board of Ethics, probably seeking a written advisory opinion as to whether that contract and whether your role in that contract can go through. Now, your county's ethics code has some very specific prohibitions on interests in contracts, and again, if it's a prohibited interest in a contract, that contract cannot be entered into. So one of them is that a contract with your prospective or outside employer, if you appropriate funds for the contract or you recommend or approve the contract, unless that contract is required by law to have been so awarded. There's also a specific prohibition for if you have an interest in a contract that is willfully entered into with the prospective or the actual employer of any relative or immediate family member, if you are the one who's appropriating the funds for the contract or recommending or approving the contract, unless the contract is required to, by law, to have been awarded that way, or if it's part of the annual adopted county budget. The Code of Ethics also contains an additional prohibition that prohibits county officers or employees from taking action or participating in any manner whatsoever in the discussion, negotiation, or the awarding of any contract or in any business or professional dealings with the county in which you, your spouse, child, and that's not limited to a child under the age of 18, child, sibling, or a member of your household within the past 12 months has or will have a direct or an indirect interest in. When the Code of Ethics refers to child, that includes your own child as well as your stepchild. And the term sibling includes your brother, sister, stepbrother or stepsister, and half-brothers and half-sisters. The Code of Ethics has some provisions that pertain to investments and also that pertain to bidding on real property. And these are very, very important for you to understand. You are allowed to invest in a private business and to engage in other commercial, financial, or other transactions while you are employed by or have a relationship with the county. However, you cannot knowingly invest in, you cannot knowingly hold any investment directly or indirectly in any business, financial, commercial, or other private transaction doing business with the county where it would create a conflict with your official duties. So this is easy if your private business has nothing to do with the county and has no relationship with the county. You need to proceed much more cautiously if that private business that you're thinking about investing in has a county contract or a relationship with the county, because it could create a conflict with your official duties. So as an example, your office is responsible for, amongst other things, ordering office supplies, and that's part of your role here. It would be a conflict for you then to go and invest in an office supply business that has a contract with the county. It would create a conflict with your duties if you're responsible for ordering those supplies. The county's Code of Ethics has an Appendix D, which lists positions and titles that are excluded from deed sale participation. If your position or title is included on that list, there are additional restrictions that you need to be aware of. If your title is on that list, you are prohibited from bidding or acquiring or purchasing any parcel or parcels of real property that are offered for sale by the county in any manner as a result of a tax delinquency on that parcel. So that prohibition is broad. It includes bidding on or acquiring or purchasing property directly, so you purchasing it directly, or you're doing that through an agent, a representative, an attorney, any third party. That includes but isn't limited to your spouse, your child, your adult child, or a member of your household. It is considered to be a violation and presumptive proof of a violation if you acquire any interest whatsoever in property, real property that is offered for sale through the county due to a tax delinquency, if you acquire that property within 2 years of the date upon which the property was sold or conveyed. So you can't have your sister, who maybe she lives down in Florida, purchase that property for you because you can't purchase it yourself. You can't use that third party to purchase that property and resell it to you. And if it is resold to you within 2 years, there's a presumption that you have violated this provision. But even if you wait for 2.5 or 3 years, while there's not a presumptive proof of a violation, it is still a violation of the Code of Ethics for you to purchase that property through that third person. They can't buy it and hold it for you and then just sell it to you later. Now, there is an exception if that property that you're seeking to buy adjoins your own property. If it adjoins your own property, you can submit a written request to the county's Board of Ethics asking to purchase that parcel, and you have to get written approval from the Board of Ethics. They can deny that approval if they believe that there is the existence or the appearance of a prohibited conflict of interest. But otherwise, if that property is adjacent to your own property, this is not an absolute prohibition. You do have to go through that process and get permission. The Code of Ethics has some provisions that are called anti-nepotism provisions. And basically, they are seeking to regulate and control the hiring of relatives of county employees and to put some procedures in place. You and your relatives are allowed to work for the county. There is nothing that prohibits your relatives from being hired by the county, or if they're already working with the county, they may continue to do so. The Code of Ethics, though, now requires that no county officer or employee who has actual authority to cause the hiring of anybody can participate in the decision to hire any relative or immediate family member or member of the household. And by actual authority is presumed even if the person who is making the offer to the person is not the relative or immediate family member, but it's somebody who serves at the pleasure of the relative or immediate family member. So if there is somebody who is applying for employment with the county who you have the authority to cause the hiring of, or somebody who you have appointed is the one who would be doing the hiring of that person, you cannot be participating in that decision, and the person that you appointed can't participate in that decision to hire a relative or immediate family member, so that would include your spouse, the unemancipated child under the age of 18, somebody who is declared as a dependent on your tax return, or somebody who is living in your household currently, or who regularly and continuously lived in your household within the last 12 months. In addition, there is a requirement that applies to all county employees, regardless of whether you have any actual authority to hire people. If you learn that someone is seeking a contract or employment with the county who is equal to a first cousin or closer relative to you through a blood relationship or through marriage, or someone who is a member of your household, you, as the county officer or employee, must disclose that familial relationship upon learning that the person is seeking the employment or contractual relationship with the county. You have to do that at the earliest opportunity next following the date upon which you first learn of or have knowledge that that person is making or has made an application for employment or appointment by the county. You would send a written disclosure to the chairman of the Board of Ethics, and you're also going to include that when you file your next annual financial disclosure statement. The next topic we're going to talk about is gifts. As a county employee or officer, you are prohibited from accepting or soliciting a gift or gifts from the same individual or entity in a 12-month period that have a total value of $75 or more. Now, we're not saying that your mother, that your spouse, that your children or others who live in your household can't give you a gift. There are exclusions from the definition of gift when it comes to people with whom you have a personal relationship, as long as the gift is being given based upon your personal relationship and it's not designed to influence you in your official duties and responsibilities, then it would fall within that exclusion. Also excluded from the definition of gift are items such as free meals that are given at a professional conference, awards, plaques, honorary degrees, promotional items that have no real resale value, so those t-shirts with company logos and the pens, those are all acceptable. There's also an exclusion for food or beverage valued at $20 or less, so long as what you receive from the same individual or entity does not exceed a total of $75 in any 12-month period. Complimentary attendance at a bona fide charitable or political event is excluded from the definition of gift, and complimentary attendance at a widely attended event where you attend that event, you're invited to attend related to your official duties with the county. Perhaps you go and perform some ceremonial function on behalf of the county, such as at a charity dinner, and they have you come and read a proclamation on behalf of the county. You are allowed to accept a complimentary ticket in that situation. However, if the charity or the nonprofit says, why don't you bring your spouse or your girlfriend, boyfriend, bring somebody with you, and they give you 2 tickets, that would be a problem, because you can accept a complimentary gift on your own behalf and attend and perform your official function, but to accept the second ticket on behalf of somebody else, that would be a gift, that second ticket. Now, regardless of the value of the gift, and regardless of whether it's worth less than $75, you are prohibited from accepting any gift or any type of financial benefit at any time where it could be reasonably inferred that that gift was intended to influence you in the performance of your official duties, or that it was intended as a reward for your work or your official actions here at the county. So you can't accept any kind of gratuities for work that you've performed. You can't accept payments for expediting an application or a permit or any other additional payments for the work that you do here in the county. Now, one of the tough areas is sometimes, particularly around the holidays, people send gifts. They send the gift to you at work. It could be a vendor sends you a really nice case of wine, and it's delivered, and you can't accept it. You have to send it back. You tell them, we cannot accept this. If it's worth more than $75, you can't accept that case of wine. Now, I've heard people say, well, what if I take a bottle and everybody in my department takes a bottle, and then nobody's taking anything that's worth $75 or more? That doesn't work. If the gift was worth more when it was given to you than $75, you can't divvy it up and then make it full below. It doesn't work that way. You also can't send, perhaps the person sending the gift has a matter that's before your department, and maybe they're trying to get you to focus more on their particular matter. You can't say, we can't take this because it could reasonably be inferred to influence us, but the people down the hall, that department doesn't have any matter before you right now, so why don't you give it to them? You can't do that. If you couldn't accept the gift, you can't have it given to anybody else. Likewise, sometimes people invite you to ball games, and those tickets these days, it's hard to find a ticket that's worth less than $75 to some of the major sporting events. And you can't accept that, and you can't say, why don't you give it to my spouse? If you couldn't accept it, you can't have it given to someone else on your behalf. That would also be improper. Use of county resources. The county has lots of resources, equipment, and supplies, and they all need to be used only for official county purposes. You cannot use your county office or county resources or equipment or supplies for private purposes. So you can't do work in your home using some of the tools that may be available here in the county, even if you're just borrowing them and bringing them right back. You can't run a private business using your county phone, your county computer, your county office, or your email system. The next topic is use of the county's official name, seal, or authority. The county's official name, seal, and authority cannot be used for any private or non-county purpose or in connection with any private or non-county function, organization, entity, group, or event unless you receive advance authorization to do so. Political activity. The county's Code of Ethics prohibits any county officer or employee from directly or from indirectly using their authority or their official influence to compel or to induce a subordinate to participate in an election campaign or to contribute to a political committee. So this means that you can't ask somebody who works for you to work on a political campaign, and it doesn't matter whether you ask them outside of the office or outside of work hours. You can't ask them. If they work for you, if they're a subordinate, they cannot be asked to do that. In the course of your employment or your relationship with the county, you will learn confidential information at points. You cannot disclose confidential information that's acquired in the course of your official duties, and you cannot use that information to further your own or anybody else's personal interests. Before you disclose any information that might be confidential, you need to speak with your supervisor, and you need to seek a written determination from your department's records access officer so that you will know whether that information is in fact confidential if your supervisor can't clarify that for you. Now, that obligation to keep information confidential continues forever, even after you are no longer associated with the county. It applies regardless of how the information was obtained, even if that information was obtained through means other than your work here in the county. If it's confidential information, it has to remain confidential. Now, while you are working for the county, you are allowed to have outside employment at the same time. And many people do, in fact, have other jobs or other businesses. You do, however, have to be sure that your outside employment does not in any way create a conflict with your official county duties. For example, if you are responsible for assigning service providers to county clients, you can't then work for an outside agency that provides services to county clients and then assign those clients to that outside agency and then go and provide the services and get paid through that outside agency for working for the clients that you have assigned there. Now, you're allowed to seek private employment, such as a second job, while you work for the county. You're also allowed to seek future employment while you work for the county. You cannot, however, solicit or accept private employment or render services for your own personal benefit when you're doing so creates a conflict or impairs the discharge of your official duties. Now, you also need to be sure that you follow any procedures or restrictions that your particular department may have before you seek or engage in outside employment, as there may be additional requirements depending upon your job and your department. Now, at times, you may have a need to appear before a county agency or department regarding your own personal matters while you are still working with the county or while you have a relationship with the county. You are allowed to appear before a county agency or department, including the agency or department where you serve, but only when you are doing so on your own behalf or on behalf of the county, or if you are an elected official or an attorney therefore. You cannot otherwise appear while you are a county employee. This means that you cannot appear on behalf of anyone else. This also means that you cannot represent a private interest before any county agency or department while you are working for the county. And by appear, an appearance is very broad, and it includes any kind of communication in any form, whether a phone call, an email, or an in-person stopping by that department. You cannot appear before a county department or agency on behalf of somebody else, only on behalf of yourself. So you can go to the planning department regarding proposed work that relates to your own personal property. You can go to the Department of Social Services regarding a personal matter. You can't go on behalf of your cousin, your neighbor, or a client of yours. And this restriction on appearances applies without regard to whether you are being compensated for the appearance or whether you're doing so pro bono, other than where the communication involves a ministerial act. The Code of Ethics also contains a provision regarding representation by a county officer or employee as an attorney or counsel. You cannot represent someone as an attorney or counsel against the interests of the county. This includes in any litigation in which the county is a party, or in any action or proceeding in which the county or any other county officer or employee acting in the course of his or her official duties is a complainant. You are not, however, prohibited from representing yourself in an action against the county. Excluded from this restriction on representation are the following: where an elected official represents himself or herself in any litigation in which the elected official has standing and authority to participate by virtue of his or her capacity as an elected official, or where an elected official is representing himself or herself in an election law matter. Also excluded is representation by a county officer who is not a county employee, other than if the representation is before the county department or agency for which the officer serves. When your relationship with the county ends, there are some restrictions on your activity after you leave the county. For 2 years after your employment with the county ends, you cannot represent or render services to a private person or organization in connection with any matter that involved the exercise of discretion, non-ministerial discretion, before the county office where you served, unless you are requested to do so in writing by the county executive or the chair of the legislature. The Code of Ethics contains a 6-month restriction for appropriators or authorizers. If you were responsible for appropriating funds for the effectuation of, or for negotiating or authorizing a contract, or for signing a contract, you may not ask for, pursue, or accept a private post-government employment opportunity with any person or entity who actually received the contract while the matter is pending or within 180 days of its final disposition. The restrictions on post-government employment may be waived by the Board of Ethics, where the appropriating, negotiating, or contracting person had no direct involvement with the selection of the contractor, or where the involvement was limited to issuing an approval or appropriation for a recommended contractor that the approver or appropriator was not otherwise involved in selecting. Or the provisions may be waived where the restrictions would cause a financial hardship for the county officer or employee. Now, the Board of Ethics actually has the ability for 2 years after you are no longer associated with the county to take action against you if you violate any of these restrictions. And they continue to have ongoing jurisdiction during that 2-year period. Provisions of the Code of Ethics can be waived. You can apply to the Board of Ethics for a waiver. The form for requesting a waiver is available through the Secretary to the Board of Ethics. You may apply for a waiver from any of the standards that are set forth in the law, but you will have to show that there is a compelling need for the waiver. If you do submit a request for a waiver within 5 business days of its receipt, the Board of Ethics will acknowledge receipt of your request. The Board of Ethics will try to grant or deny the waiver request within 10 business days of receiving sufficient information upon which to render its decision. Your request for a waiver will be deemed abandoned if you do not provide information that is requested by the Board of Ethics within whatever time frame is established by the Board of Ethics. Now, all of you are required to file an annual financial disclosure statement. The statement is required to be filed by all elected county officials, department heads and their deputies, employees of contractors who have authority for policymaking decisions, anybody who is listed in the list of titles and contractors that are amended to the law as Appendix A, and any county political party officials, the chair, first vice chair, second vice chair, treasurer, secretary, and sergeant at arms of a county political party, if that person or his or her successor received compensation or reimbursement of expenses from a constituted committee or political committee during the reporting period aggregating a combined total funds of $30,000 or more. Any person who will become a candidate for the office of any elected county official is also required to file that annual financial disclosure statement. Those statements have to be filed with the Secretary of the Board of Ethics within 60 days of the person taking office, or by no later than May 1 of each year, or within 7 days after the filing of a nominating petition to be a candidate for the office of any elected county official. Your annual financial disclosure statement has to be notarized, and filed with the Secretary of the Board of Ethics. The form was developed by the county legislature and is subject to amendment by the Board of Ethics. If after you file your form, you become aware that there is something on that form that you wrote in error, you have to file an amended, corrected disclosure statement form with the Board of Ethics promptly upon it becoming apparent to you that there was an error on the form that you filed. So I recommend that you maintain a copy of each form that you file so that if you do need to amend it, correct it, then you'll have a copy. It'll be much easier to file it. The form is available on the County Board of Ethics webpage. You need to carefully read the instructions on that form and complete all of the items on the form. If there is an item for which it doesn't apply to you or you have no such interest, you need to have an answer on there. You need to either state not applicable, which is NA, or none because it doesn't apply to you. Every question on that form has to be answered, and you need to write it in a legible manner or else your form will be returned to you so that you can redo it. The form does have to be notarized. There, on page 13 of the form, there is an area for you to get it notarized, and then you'll submit it. You have to make a good faith effort when you are completing that form. Say you are separated and your spouse won't give you information when you're completing that form. Your failure to disclose information that is required to be included in the annual disclosure statement when it has to do with your spouse or a member of your household or other relative, it will not constitute a violation if you have made a good faith effort to obtain that information and you're unable to do so. You have to set forth what your efforts were right on the form to obtain that information, but as long as you made that good faith effort and you weren't able to get the information and you include what you did to obtain the information on the form, you will be okay and it won't constitute a violation of the Code of Ethics. Once you send your form to the Secretary of the Board of Ethics, the Secretary will send that form within 5 business days to the Board of Ethics. The forms for the elected officials, the county executive, the district attorney, the sheriff, and the legislators are all required to be posted on the Board of Ethics website. All other forms are available for inspection and photocopying in accordance with the Freedom of Information Law, FOIL. However, prior to disclosure of anybody's form, the form is redacted by the Board of Ethics to remove your address, your phone number, the email address of any person, the names of your minor children, and any other relevant information that is determined by the Ethics Board to be necessary or appropriate to be redacted for reasons relating to the public safety of anybody, or that is otherwise permitted to be redacted under the Public Officers Law. The Ethics Board can do that redaction on its own initiative or upon your request. And they can redact as long as the information is not required to be made public pursuant to FOIL and the Public Officers Law. So you can make a request for redaction of items and they will have to determine whether it is appropriate to be redacted. The Board of Ethics will also redact the signature of the filer and the notary. If a filer's disclosure form will be disclosed, the Board of Ethics will notify that filer before the form is produced for public inspection, and they will identify the person to whom the form is being produced. There are penalties for violations of the Code of Ethics. They can range from a misdemeanor to a civil fine to disciplinary action, and they are contained in the Code of Ethics and the New York State General Municipal Law. The Board of Ethics has the power and authority to render advisory opinions to county officers and county employees. The in order to get an advisory opinion, you have to make a written request to the Board of Ethics. The request has to be signed by the person who is making the request. They will not render an advisory opinion for an anonymous request. And their advisory opinions can be rendered on the request of a county officer or employee, or a supervisory official's request on behalf of a county officer or employee. Their opinion will only apply to the person to whom or about whom the opinion is requested. It will not apply to anybody else or any other situation. The opinions that they will issue will only be issued with respect to future proposed action by a public servant. They will not render an opinion with regard to something that has already happened. Now, if you receive a written opinion, a written advisory opinion from the Board of Ethics, and you reasonably rely upon that opinion and you act in accordance with what they advised you to do, unless there were material facts that you didn't include or that were misstated, you cannot be subject to any penalties or sanctions under the Code of Ethics. The Board of Ethics may accept a complaint or an allegation from the general public, from one of the members of the Board of Ethics, or from any county officer or employee alleging a conflict of interest on the part of any county officer or employee, or concerning a violation of the Code of Ethics by any county officer or employee. The complaint has to be signed. They will not accept any anonymous complaints, and there is a lengthy procedure that they go through before they act upon a complaint, so that there is a lot of due process that is provided to employees. The Board of Ethics retains authority to take action against any former county officer or employee for a period of 2 years following the separation of that person from the county. Thank you all for your participation here today. We hope that this has provided you with guidance as you move forward in your employment or your relationship with the county, and only through everybody complying with the Code of Ethics will we ensure the transparency, the public confidence, and that the integrity of the county government continues, and the wonderful reputation enjoyed by the county and its employees is maintained. So thank you.